Did the Supreme Court just approve President Trump's $400 million White House ballroom? Or did one justice simply keep the construction crews working while the real legal fight continues? Should you even care whether you support Trump, oppose Trump, or only care about your tax dollars? Because this fight is bigger than a ballroom. It asks who controls the people's house and whether a president can make a permanent change before Congress or the courts give a final answer. That's the real question here. Look, he had an MMA fight at the White House. That's like allowing the kids to practice gymnastics in the kitchen in front of guests. It's just weird. He just so used to doing whatever he wants to do. Did you know what actually happened? Now, I'm going to tell you. On August the 21st, Chief Justice Roberts entered a short order in the Supreme Court docket 26A203. He stayed the lower court's preliminary injunction impeding further order of Chief Justice or the full court. So in plain English, the injunction is paused. Construction can now continue, better known as my balls are bigger than yours. That's what he just did. Most people will not tell you this. That is not the same as the final Supreme Court ruling that this project is legal. The order does not explain Roberts' reasoning. It does not decide whether Congress must authorize the project or not. And it does not settle the preservation group's lawsuit. That distinction matters because the lower courts had reached a serious conclusion. A federal district judge restricted above ground ballroom construction while leaving the room for underground work and activity strictly tied to security. Then on August the 7th, a divided D.C. court panel upheld that injunction. So the headline is not Supreme Court approved Trump ballroom. The more accurate headline is more like Chief Justice temporarily pauses the order that would stop above ground construction. It's not as catchy, but you get the point. Now, what does that leave? Well, that leaves the central unanswered question. When a president wants to reshape the White House, who gets the final word? The president, the Congress, private donors, preservation law, or the courts? You must remember the White House is not his personal home. It belongs to the people, not the person. Now, let me tell you how the project has been described in the court record as a 90,000 square foot ballroom with related offices and underground national security facilities on site of the former East Wing. The Associated Press and Reuters report the price is about $400 million. I have a cousin who will do it for half that, plus some Newports, menthol, of course. Just hit me up, President Trump. I got you covered, brother. Supporters described it as long-needed event space combined with major security upgrades. You know, like the one that the guy ran through at the White House dinner. Opponents argue that the scale of the above-ground ballroom goes far beyond ordinary maintenance and requires congressional authorization. What if the legal fight turns partly on the federal statute? Title 40 United States Code Section 8106, that provision says construction in the District of Columbia on covered federal land cannot proceed without express authority of Congress. The Trust for Historic Preservation argues that the executive branch is acting beyond the authority Congress provided. Lawyers call that ultra vires calm, an allegation that officials are acting outside lawful power. At this preliminary stage, the D.C. Circuit Majority said the trust had made a compelling showing that Congress did not give the executive branch unlimited power to dramatically redesign and reconstruct the White House. The majority's core point was institutional. The White House belongs to the country, and the major permanent construction is not simply a president's private renovation decision to be made alone. But there is another side. Judge Naomi Rio dissented. She argued that the trust standing was weak, that the executives has authority to improve the executive residence, and that the courts gave too little weight to the national security evidence provided, and the risk of leaving a major construction site unfinished may be detrimental. That disagreement is important. This is not a case where every judge sees the law and the facts the same way. It is a dispute over standing, statutory authority, security, equitable relief, and the separation of powers. And remember what a preliminary injunction means. It is an emergency form of relief used before a final trial or final judgment. Courts consider the likelihood of success, irreparable harm, the balance of harms, and the public interest. None of that is the same as a final ruling after the full case is completed. Okay, now you have to get your tea and your popcorn ready because we have reached the strongest contradiction in this entire story. The administration's public case leans heavily on private donations and national security. The D.C. Circuit record says the project is funded primarily through private donations to a National Park Service gift fund. The workaround. That matters when people ask who is paid, but private money does not automatically create public authority. If a statute requires Congress to authorize construction on federal land, a donor cannot replace a vote of Congress. Funding answers who writes the check. Authority answers who has the legal power to approve the project that the check was written for. Those are different questions, my friend. The second contradiction is physical. The administration says the construction is an integrated complex with essential security upgrades below ground. The trust says the absence of a ballroom is not itself a national security emergency, and the lower court attempted to separate above ground ballroom work from underground security work. That line may be difficult to draw on a live construction site. The government argues delaying creates security, engineering, and cost risks. Opponents argue the administration created an urgency by moving forward too quickly and should have not been allowed to outrun judicial review. Again, the runaround or the workaround. Then comes the political contradiction. I love this one. Presidents are expected to maintain and protect the White House. They also live there temporarily. Every president needs room to manage security and operations, while they fall asleep during, meetings. But a rule broad enough to permit one president to remake the property without Congress will still exist when the opposing party controls the executive branch. You see how much bigger this thing has become now? And why is it important? That is what the real standard cannot be decided. Do I like the president? It has to be what rule should govern every president moving forward, whether you're Republican or Democrat. Chief Justice Roberts' order preserves the administration's ability to keep building while the Supreme Court considers what comes next. It may reduce immediate construction disruption. It also increases the practical stakes because every additional week, every additional day, every additional hour of work makes the project harder and more expensive to unwind if the government ultimately loses the case. The courts sometimes consider that kind of practical harm when they make their judgment. But courts also resist allowing a party to create its own irreversible reality and then argue that reversal has become too costly. That tension, security and continuity on one side, effective judicial review on the other, is now at the center of this whole entire case. Do you now see why this is bigger than the ballroom extension? It's huge, right? So what should viewers take away today from all of this? First, I'm going to name them out for you. The Supreme Court has not ruled that the ballroom is legal. Chief Justice Roberts issued an interim stay. The merits remain unresolved still to this day, still to this hour. Second, the lower court decisions still matter. They explain why the preservation groups believe Congress must act and why two appellate judges thought the injunction was justified. The dissent explains why the administration believes courts are overreaching and underestimating security. Third, do not collapse funding and authority into one issue or one big bucket. A project can be primarily privately funded and still require legal authorization. A project can contain real security improvements and still include above ground construction that a court treats differently. Fourth, watch the docket, not the slogans. That's the biggest one. The next meaningful order may come from the Chief Justice or the full court. The justices could continue to stay, narrow it, lift it, request more briefing, or eventually address whether to take the underlying dispute. The best rule is one you are willing to live under when your least favorite politician becomes president. If Congress has a required role, that role should not disappear because private donors are available or because construction has already moved so quickly. If the executive possesses lawful authority to protect and improve the residents, courts should not manage every engineering decision from the bench. That's the balance in this case must be resolved. The ballroom may be a visual symbol, but the lasting decision will be about presidential power, which Trump continues to test, congressional control of federal property, and whether judicial review can happen before a disputed project becomes a finished fact. For today, construction continues. The legal fight does too. And anyone telling you the Supreme Court already decided the whole case is giving you a headline and not the law, and definitely not the facts. Personally, I believe Trump should have gotten authorization first. That makes sense. And then the money. Tell me what you think. Comment below. This is Money in Politics Simplified. I'm Esco Latimer. Please like, follow, share, and comment. Should Congress have to approve a project this large at the White House, even if private donors pay most of the costs? Just because you pay don't mean you get to stay. Stay informed, stay engaged, because when you understand the money, my friends, well, of course, you understand the politics. Next, watch my breakdown of the FBI search involving Eric Swalwell, the guy in California, because the story makes the same essential distinction, except for the sexual scandal part. A temporary legal step is not final verdict. Click the video now. I'll show you what a search warrant proves and what it does not prove.
Esco Latimer. Talking money, talking power. Follow the paper and you find a throne. Deals in the back while the cameras roll. Who's funding fear? Who's buying hope? Who's pulling strings every time we vote? Money in politics.